was 235 years ago, on September 13th, 1787, that the founders almost signed the Constitution. Actually, they made a few wording changes to Article 1, listened to George Mason bemoan that the draft Constitution did not empower Congress to deploy sumptuary regulations, what today we would call sin taxes. But nevertheless, they made progress with the finishing touches that would eventually become the final draft of the Constitution, which was signed 4 days later on September 17, 1787. We celebrate today rather than on September 17, the day the founders actually signed the Constitution, because this year the 17th falls on a Saturday. And in providing for the celebration of our Constitution, Congress declared that institutions like BYU can choose a nearby weekday to celebrate should the actual day fall on a weekend. As a historian who cares about dates, this hurts deeply. We like to get our dates right, or at least, and at a minimum, explain why we have intentionally gotten them wrong, hence my explanation. In any event, in picking a day to celebrate, we here at BYU know that Tuesdays are the days we typically hear important addresses from important people. Many of us here have already heard one earlier today from Elder Oaks, hence our choice of Tuesday to celebrate the Constitution's birth. On behalf of all of today's sponsoring institutions, we are very grateful that Noah Feldman has taken time to be with us and share insights from his recent book, The Broken Constitution, Lincoln, Slavery, and the Refounding of America. We will hear more about him in a moment. We also want to thank all of you for joining us, and that includes our online audience. In particular, if I may, I'd like to acknowledge a few people in attendance who mean a lot to the BYU community and this event. With us here today is Elder Jeffrey Holland, Elder D. Todd Christofferson and his wife Catherine, Elder Clark Gilbert, and Brother Ahmad Corbett from the Young Men's General Presidency and his wife Jane. We also have President Kevin Worthen and his wife Peggy, and a handful of members from the Wheatley family, who are, as I mentioned before, the sponsors of the Wheatley Institute, which is a sponsor of this event: Charles, Shauna, John, and Diane. We have a number of academic vice presidents with us as well, Shane Reese and his wife Wendy, and we also want to acknowledge the Honorable Judge Thomas Griffith, who is formerly of the Washington, D.C. Circuit Court, and we will hear from him a little bit more as well. And then also Paul Edwards, who's the director of the Wheatley Institute and has worked so much with me in putting this event together. I also want to just take one moment to thank Ariel Wong for providing the music for our event. People who know BYU know that we are a people given to prayer, and today is no exception. We have asked an undergraduate here at the university, Brittany Leonard, who is a history teaching major from Azle, Texas, to offer our invocation. Brittany. We want to hear as much as we can from Professor Feldman, but we also want to know a little bit about him before he begins. So we have asked Judge Thomas Griffith to introduce us to Noah. And after Tom's introduction, the time will be Noah's until about quarter till the hour, at which time we'd like to have a short question and answer exchange. Tom.
Noah Feldman is the Felix Frankfurter Professor of Law and Director of the Julis Rabinowitz Program on Jewish and Israeli Law at Harvard Law School. Professor Feldman's academic credentials alone merit listening to what he has to say. He graduated first in his class at Harvard College, earned a DPhil at Oxford, where he studied as a Rhodes Scholar, and took a JD from Yale. He clerked on the Supreme Court for Justice David Souter, but more important than that, he clerked on the DC Circuit for Judge Harry Edwards. As you will soon see, Professor Feldman is that unusual scholar who can teach the non-specialist the complexities of a topic in a way that is not only understandable, but serves invariably as a call to action. And it seems that he is always calling us to action by his example and his scholarship, which have thrust him into some of the most consequential issues of our time, whether that be trying to build democracy abroad, preserve religious liberty, the role of the Supreme Court under the Constitution, the impeachment of a president, and even the ethics of the digital world. Although it is not a topic that he will address today, I have a suspicion that one of the reasons Professor Feldman accepted the invitation to be at BYU is that he has a deep interest in Latter-day Saints. Indeed, his commentary about us is among the most interesting and insightful that I have ever encountered. I commend to you his entry on Latter-day Saints and American politics in the Oxford Handbook on Mormonism, and his recent interview with Terrell Gibbons and Zach Davis on the Faith Matters podcast. It is with great pleasure that I introduce to you my friend, Professor Noah Feldman.
Thank you, Judge Griffith, so much for that much too generous introduction. If you would consider sharing with my mother, I think it would make her extremely happy. I'm grateful. I'm really deeply honored to have the opportunity to be here with all of you, those present and those online. And in particular, I'm really honored that Elder Holland and Elder Christofferson and Catherine are here as well. And every time I speak in front of Judge Griffith, I think to myself I should begin, may it please the court. So if you'll all take yourselves as the court, I hope that what I have to say will be pleasing to you. I love the fact that people say that when they get up to make an oral argument in court, because whatever you're about to say, it never pleases the court. So it's a particularly strange performative contradiction, but tradition can sometimes be that way. I'd like to speak today about a particular moment in the history of our Constitution, the moment that accompanied the period from early March of 1861, when Abraham Lincoln became president, was sworn in as president, and January 1st of 1863, so not quite 2 years later, when the final draft of the Emancipation Proclamation was formally issued. There's never been a more intense or transformative period in the history of the US Constitution, and simultaneously, there's never been a more tumultuous period of time in the history of the Republic. And it's a little bittersweet to speak about these events on an occasion, though, as we've just heard, not the day of Constitution Day, because I have a reverential attitude towards the Constitution, and I've spent most of my adult life studying it and engaging with it and trying to impart the best of it, though I hope only the best of it, to people in other countries. And the period I'm talking about today is the period where the Constitution was broken. Initially, and most fundamentally, it was broken by the secession from the Union of the Confederate States. And then, as I'm going to suggest, in complex ways, Lincoln had to engage with the Constitution in terms that could be categorized as themselves breaking the Constitution. That's a bit more controversial, and I'm going to talk about that in more detail. And so if you have reverence for a person or a document, it's not natural to begin your conversation in reverence with an invocation of what is arguably the worst period of time in the life of that person or that individual. But we can imagine, and I hope that you'll be convinced of this by the end of my remarks, that if we knew someone who had been through a crucible, an extraordinarily intense period of time in his or her life, where the stakes were the highest they could ever be, existential, and where with effort and engagement and thought and prayer, that person made it through and came out better on the other side, then indeed it would be appropriate to speak about that in the context of showing reverence for that person or that institution. So it's in that spirit that I'm going to speak about this period in the life of our Constitution. Now, when Abraham Lincoln was sworn in, he faced challenges unmatched in the history of the presidency before or since. The country had never before, it had been close to potential secession before, but it had never actually happened. And although Fort Sumter's shots had not yet been fired, Lincoln could see and was being told throughout the next several weeks by his military advisors that the South Carolina troops were about to fire on a US military installation. But that was not the most serious problem that faced Lincoln. the most serious problem that faced Lincoln had to do with the oath he had sworn to uphold, protect, and defend the Constitution. And I want to begin with that oath, because Lincoln thought it was so important that he mentioned it in his first inaugural address. Lincoln's first inaugural address does not get very much attention. And that's probably a good thing. I noticed on the way in leaflets telling us that on Thursday there will be an event and a film about Lincoln's religion in his second inaugural. And I was very glad to read about this for two reasons. One, I'm very interested in religion in Lincoln's second inaugural, and I think I'll be able to watch it online. I wrote about it in my book, and now I know not to speak about it today. But second, because it gives me an opportunity to point out that Lincoln's second inaugural is justly famous and can be seen in the Lincoln Memorial up on one of the walls in parallel to the Gettysburg Address, which is on the other wall. And in all the times that I visited the Lincoln Memorial, it never once occurred to me to ask why the second inaugural was there, but not the first inaugural. And in fact, I had never read the first inaugural in detail until I did research for this book. And I was frankly a little shocked at what I found, because in the first inaugural address, Lincoln opened by insisting that he was fully prepared to protect the Constitution's guarantee of slavery, and that if necessary, he would even acquiesce in a constitutional amendment, though he believed it was unnecessary because he was committed to the idea that the Constitution as written that he had inherited and that he had just sworn moments before to protect guaranteed slavery and protected it from any intervention by the President of the United States. And he bent over backwards to make this clear. He said he was saying it without any mental reservation and without any, what he called hypercritical thinking, by which I wasn't sure exactly what that meant. I had to look it up in context. He meant no hair splitting. He meant, don't think I mean this, but I don't mean that. And it's probably a good thing that he said that, because pretty much since that moment, people have been claiming he didn't mean what he said. So I'm going to leave aside whether he meant what he said there, but he said it, and he said that he meant that he said it. So that's why we don't talk a lot about the first inaugural. But Lincoln went on in that first inaugural to speak in very important terms of what he called an oath I have registered in heaven to protect the Constitution. So he was talking about the oath of office that he had just taken. And although Lincoln's religion is a topic of ongoing fascination, because as probably all of you know, Lincoln was not very attracted to organized religion, and at some times in his life expressed views that sometimes verged on the, let's politely call them agnostic. At other times, he spoke eloquently in profoundly religious terms, as indeed he did in the Gettysburg Address and especially in the second inaugural. So when Lincoln spoke of the oath being registered in heaven, he was trying to communicate to his audience the deep, deep seriousness with which he took his obligations under the Constitution. Now, that could be boilerplate. You're the President of the United States, you've just been sworn in. Naturally, you should say that your oath is registered in heaven, right? Maybe it's just a form of words. Well, it wasn't just a form of words, and the reason it wasn't just a form of words, and that we can know that for certain, is that while saying that, Lincoln was confronting the first of what would be three fundamental problems for the next 19 months of his presidency, all of which had to do with, you guessed it, the Constitution. So what were those three problems, and what was the first one confronting him? The first had to do with what he was authorized to do under the Constitution about the fact of secession. Now, if you're like me, you grew up hearing that after the South seceded and shots were fired on Fort Sumter, Lincoln took the country to war to preserve the Union, and no one ever mentioned, certainly no one ever mentioned to me, that there was a constitutional question of whether the president, acting on his own or with Congress, had the authority under the Constitution to make war on a number of the states of the United States. I was brought up to take it for granted that, of course, the job of the President of the United States was to use all the force at his disposal, including the coercive force of war, to fight those who would have seceded from and broken the Union. And that's, it turns out, because Lincoln was so good at convincing us of that, that we've believed it ever since. But just a few months before Lincoln became president, the Attorney General of the United States had issued an official opinion stating in great detail that there was no authority in the President of the United States to use coercive force, including war, to force states to re-enter the Union. And it wasn't just the Attorney General's opinion. The President of the United States before Lincoln, James Buchanan, in his last State of the Union address, devoted several pages. In those days, the State of the Union address was just a written document. It wasn't delivered orally. The President would just send it over to Congress. So in Buchanan's address, the State of the Union address, he had devoted multiple pages to repeating and amplifying his own Attorney General's argument. And the core of that argument could be summed up in the words, consent of the governed. So there are a lot of students here, and I'm thrilled by that. I'm never happier than when I'm talking to students about the Constitution. I'm one of the luckiest people in the world because I get to do as my job one of the things I like to do the most. And today I'm just doing it with a slightly more beautiful background than I do at home. And so the consent of the governed is probably the single most fundamental principle that underlies our Constitution, because it underlies both the idea of the sovereign people voting to elect their representatives. The people have to consent to those representatives being elected. The people have to consent to the laws that are adopted. And the people also consent to the fundamental rights that they have. We, the people of the United States, are engaged in consent in every stage of constitutional thinking. And according to Buchanan, his Attorney General, and many other thinkers about the Constitution before them and at the time, if a group of people got together in a state, formed a convention, the same one that had been used to ratify the Constitution, and unratified the Constitution in that state convention, then they had revoked the consent that they had previously given. I mean, after all, how was the Constitution ratified? September 17th is the date not when the Constitution was ratified, but the date when the people who had gotten themselves together and usurped the authority to write a new draft Constitution, which no one had given them, and voted to pass the document that they had written to Congress with a recommendation that it then be ratified by the states. So legally speaking, nothing happened on September 17th. I mean, don't tell Congress. I mean, they did send a letter to Congress. Maybe that's why Congress thinks that's the most important date in the history of the Constitution. But nothing juridically had actually happened that day because the consent of the governed was necessary to adopt the Constitution. And one of the principles of consent in every aspect of our lives is that if it's given, it can ordinarily be revoked. Otherwise, I'm not a sovereign. A sovereign gives his or their consent, and a sovereign can retract consent, and that is literally the definition of being a sovereign being. And so those who believed that the people of the southern states had exercised their retraction of consent thought it followed that for the government of the United States to make war on them and force them back into the Union, notwithstanding their retraction of consent, violated the most basic principle on which the whole republic was based. So you all see the problem. And Lincoln needed an answer for it. And here I want to say what I hope will be a nuanced point that also will be part of, I think, the most challenging thing that I'll say today. And that is that Lincoln himself had to figure out how to interpret the Constitution to which he was swearing an oath registered in heaven in order to know how to fulfill that oath. If he interpreted the Constitution the way Buchanan had done, his duty was to stand back and allow the southern states to secede. If, in contrast, he interpreted the Constitution as he came to over the next weeks, to say that he was charged by the Constitution to execute the laws faithfully, and that the laws could not be executed if the state had seceded, and that secession was invalid, not a genuine exercise of the consent of the governed, then it followed that he did have to do the thing that we were brought up to believe he must do, namely go to war and force the southern states back into the Union, whatever the cost. And Lincoln did not know initially exactly what he thought the Constitution meant on that point. And so what I'm suggesting is that in order to fulfill an oath you've taken to the Constitution, you first have to interpret that document to know what it demands of you. Now that may sound obvious, maybe I made it sound too good, but in a moment you'll see why it's challenging. Lincoln concluded that that was his obligation. He began to explain in that first inaugural why it was his obligation to go to war, and in the weeks and months that followed, that is exactly what he did, with the caveat that he had almost no troops to work with. He had to ask for volunteers, and volunteers had to be raised. They really weren't trained. There wasn't much time. They were put in trains, and they were sent south. And the first task was to protect the capital, which after all was between Virginia and Maryland. Virginia had not yet seceded, but it soon would, and many people thought that Maryland might secede. Maryland was a slave state. And that led in April and May to Lincoln's second fundamental constitutional challenge. And that had to do with what you should do about resistance, armed resistance to those troops. So as those troops came, the first group came from Massachusetts actually, and they came in trains, and when they got to Baltimore, they had to change train systems crossing the harbor. So probably this is not very many people in the room, but how many people here have ever driven into Baltimore from either the south or the north? Oh, that's pretty good. So as you probably remember, it's a little easier if you have a GPS guiding you, but you have to change highways, and you have to go through, nowadays, a tunnel that will take you under the harbor, because if you went around, it would be extraordinarily time-consuming and difficult. So the same was true of the train systems. And to get to Washington, D.C. from Boston, you have got to go through Baltimore. And so the way the train system was set up at the time was that you got off the train, and then the train would be hauled by horses a mile over ground, where it would connect up to a different set of train tracks that would bring it south. And when the Massachusetts troops got out of the train, they were met by a mob of some 10,000 people who were not happy to see them. The mob was there to say, we don't want you in our state, we don't want you in our part of the country, and the people in that mob were sympathetic to the Confederacy and did not want the Massachusetts volunteers going anywhere. And if you ask yourself, well, this was a highly sensitive movement of troops, so why did the crowd know they were coming? The answer is that at every whistle stop between Boston and Baltimore, the troops had been applauded, met with brass bands. It was huge national news that they were making this trip. It was hugely important politically for Lincoln to show that people liked this. And so everybody knew exactly where the troops were going and when they were arriving. And as the troops tried to work their way through the mob, violence broke out. Somebody shot first, nobody knows who, and about a dozen people in the crowd were killed and several soldiers as well. And almost immediately, the printmakers, Currier and Ives, produced a print that was a copy of the famous print of the Boston Massacre. And the point was to say that this attack was like the Boston Massacre, and the analogy was the federal troops, or the Union troops, were just like the British occupying troops. That was the analogy. It wasn't that the troops were being massacred, it was that the troops had done the massacre. And as it turned out, it wasn't just an isolated incident. Maryland state militia, whether acting on orders of the governor or not remains contested to this day, actually burned railroad bridges all around the area to make it even more difficult for troops to come through. Now, from a military standpoint, this was nothing less than a disaster, and Lincoln had to do something about it. The problem was, what? What could you do about it? The people who had engaged in these acts were not technically at war with the United States. They weren't belligerents in an ordinary conflict. In fact, throughout the war, Lincoln never acknowledged that the Southerners were legitimate combatants entitled to the protections of the battlefield. So what was he going to do? Charge them with a crime, arrest them, put them to trial? I mean, it sounds good, but would a jury in Baltimore have convicted these folks? Given that 10,000 people had met the train, it seems relatively unlikely. So Lincoln authorized his generals to pull the emergency cord that is in the Constitution of the United States. It's not always recognized, but we have a break glass provision in the Constitution. And it's called the suspension of the writ of habeas corpus. Now, that is a fancy lawyer's way of saying that once the writ is suspended, any federal official who's authorized to do so can arrest, to use colloquial terminology, grab up anyone the federal official thinks is a problem, put them in prison, and let them out whenever or never. That's suspension of the writ of habeas corpus. Because habeas corpus is the principle of the Constitution that says that if the government grabs you up, they have to appear in court and convince a judge, an independent neutral arbiter, that you have violated an actual law of the land and committed a crime. Then you can be detained for trial. If you're convicted, you stay in prison. If not, you go free. That is rule of law 101. And in fact, if you don't have that, you don't have the rule of law. So Lincoln suspended the writ of habeas corpus, which you'd think would be fine until you go and look at the Constitution. There is a provision there that says that in times of war or rebellion, the writ may be suspended. But it's located in an awkward place. It's located in Article 1 of the Constitution, Section 9. And for those of you who remember the Constitution from either 8th grade civics or your AP US government or history classes or current constitutional law class, Article 1 is the section that talks about the powers of Congress. And Article 8 is the laundry list of their powers. I see some people nodding, students, which is good. And Article 9 has a few things they can't do. And the executive will not be mentioned until Article 2 of the Constitution, a whole other article. So from context, it is as clear as it could be that the power to suspend habeas corpus belongs to Congress. Congress was not in session, and Lincoln didn't want to wait for them. So he acted unilaterally. And in issuing his initial justification, he said nothing about why he had the right to do this. On July 4th, a few months later, when Congress did come together, Lincoln did explain why he had suspended the writ of habeas corpus to Congress in the course of asking them if they would ratify his action. And he basically said, it was an emergency, I had to save the republic, I had to suspend habeas corpus, the troops had to get through. And anyway, it doesn't say the words, only Congress may do this. So I was really authorized, but please now justify it for me. To which Congress said, nope, not gonna do it. And it was another 3.5 years before Congress ratified his suspension of the writ, and during that time, Lincoln continued to keep habeas corpus suspended. And the sitting Chief Justice of the United States, Roger Taney, issued an opinion called Ex parte Merriman, explaining in a lot more detail than I just did why the president did not have the authority to do this without Congress, and directing the president to free a particular person who had been suspended for burning bridges. And what do you think Lincoln did? Nothing. He ignored it. He ignored it all the way through. Now, Lincoln, to reach this conclusion that he had this power, while remaining true to his oath to uphold the Constitution, had to interpret the Constitution, let us say, afresh. No one in the history of the United States had previously ever thought the president could do this. And Tawney pointed that out in his opinion. He said Thomas Jefferson, who came close to doing this once, was going to ask Congress to do it when Aaron Burr rebelled. And even Jefferson never said privately or publicly, oh, I can just do it on my own. I don't need to go to Congress. So how could Lincoln have done such a thing? And how could he have sustained it in the face of the two other branches of government telling him no? In the case of the court explicitly, and in the case of Congress implicitly, by repeatedly refusing to ratify his decision. Well, the answer is that he had to interpret the Constitution in the light of his own beliefs about what was necessary, that was his key word, to save the Union. When he interpreted the Constitution in the light of that, he was acting in conformity with his oath registered in heaven and not in violation of it. So now you should be seeing why there is something challenging about the idea that I have to interpret the document in order for me to conform to my oath to follow it. Because who says that I, even if I'm the President of the United States, am right about the meaning of the Constitution? And who says that when I look into my conscience to attempt to give the best interpretation that I can, that I'm not influenced by my own preferences, desires, needs, or interests? Lincoln was a fallible human being. I mean, in retrospect, we see him as a saint of the Constitution, both for what he accomplished next, which I'll come to in a moment, and of course because of his assassination, which made him in civil terms a martyr, and perhaps even in religious terms, a martyr to the Constitution. So now we think in retrospect, the man could do no wrong, literally. But he couldn't have thought that about himself. He knew otherwise. And he had spent his entire life emphasizing the importance and the value of the rule of law and of abiding by the Constitution. And he could not admit to himself that he was violating the Constitution, because if he did, then he was violating his oath. This is a kind of figure, I think, of a challenge that could face any of us, even not faced by the same set of circumstances, when we have a deep and profound commitment to following a teaching, when we can find authoritative sources that explain that teaching, but when that teaching nevertheless is subject to interpretation. We can't keep our oath without interpretation. We have to do that first step. Can we trust only ourselves? Should we rely on other authorities? In the case of Lincoln, the two other authorities were the other two branches of government. He didn't rely on them. This is why it's a challenge. And it was a challenge for Lincoln that fundamentally was going to determine the future of the Republic. So I'm coming now to what I hope is the culmination of the challenges that Lincoln faced. And it's a challenge that was much harder for him than going to war or suspending habeas, both of which decisions he made in relatively short periods of time, weeks or short months. This one took him a year and a half. And that was the decision that made Lincoln a figure for the ages, namely the decision to exercise his own authority as president to emancipate enslaved people, not in those parts of the Union that were still part of the Union. The Emancipation Proclamation did not, in fact, apply to enslaved people in, for example, Maryland, which never did secede, but to emancipate enslaved people in the Confederacy. Now, why was this hard for Lincoln? Well, I've already mentioned to you his inaugural address, where he told the world that he had an oath registered in heaven to follow the Constitution, and that under the Constitution, as he understood it, with no secret reservations and no hair splitting, he lacked the authority to do anything about slavery. And this was the view of a lifetime. In 1838, as a very young politician, Lincoln's first major speech was given in Springfield, Illinois, at the Young Men's Lyceum. It's called the Lyceum Address. You could look it up online, put those words in, it'll come up. The Lyceum Address includes Lincoln saying that, and by the way, the Lyceum Address is all about the value of the rule of law and the necessity of following the Constitution and following cold reason, not warm passion. And in that speech, Lincoln gives an example of the kind of passionate action that we should never do under the Constitution. And he says there are some people who want to be great men of history, like a Napoleon or an Alexander the Great. And he says those are the kind of people who, regardless of the laws, would enslave free men or free enslaved men. And he says that's the very archetype of what we should not have under our Constitution. So Lincoln believed, and had believed in conscience for his whole adult life, that slavery was morally wrong, but that it was his obligation under the Constitution to protect and uphold it. And in the period of time between his inauguration and September 22nd of 1863, when he issued a draft of the Emancipation Proclamation, he flipped. He flipped 180 degrees. And through his letters and papers, we can say with a fair amount of precision when he flipped. So for example, on September 22nd, 1861, sorry, I misspoke, 1862 is the date of the draft. On September 22nd, 1861, about 6 months after taking office, he wrote a letter which he knew could be made public to an Illinois friend of his called Orestes Browning. And in the letter, he was talking about an effort that had been made by one of his generals to emancipate slaves in area under that general's control. And in that letter, Lincoln said that it was completely unlawful for his general to do that. He had reversed the general's order and fired the general. And he said, Lincoln said, to emancipate slaves like this is an act of dictatorship. Lincoln's words. Exactly 1 year to the day before he issued a draft of a proclamation doing precisely the thing he had said was unlawful under the Constitution, a violation of his oath. So how did he get there? That's a process you'll have to read the book to see in detail. And it would be in order to show something like that, you have to try to get inside somebody's mind, and you have to rely on every last little bit of evidence, and you have to deploy the tools of the historian's craft, which is to use just enough imagination to understand the person while being responsible to his actual words recorded in the sources. My own interpretation, to give you the bottom line, not the reasoning, is that what Lincoln had done with respect to habeas corpus had taught him the principle of necessity. It had taught him the syllogism that he was sworn to uphold the Constitution, that the Constitution demanded the preservation of the Republic, that he must do everything necessary to preserve the Republic, and that that included taking steps that under other circumstances would have violated the Constitution, because it was necessary to achieve the goal of winning the war and preserving the Republic. That form of reasoning led Lincoln to the greatest moral accomplishment, I think it's fair to say, of any president, and perhaps the greatest moral accomplishment of any one person in the United States government. But by Lincoln's own lights, a year before he did it, it would have been an act of dictatorship in violation of his oath. So Lincoln had to reinterpret the Constitution in light of the necessity and the circumstances of the moment. And by doing that, he reached a conclusion that I think today we essentially all agree was an act of profound moral correctness. So much so that we associate it with Lincoln's long-term worth and value. He became known forever as the person who freed the slaves. It's worth noting, of course, that no actual person went free as a result of this declaration, because the people he was nominally freeing were literally living in the Confederacy. They had to free themselves. But Lincoln was at least saying that if they did free themselves, they would not be returned to bondage, which had happened previously. Some before this declaration, before the Emancipation Proclamation, some enslaved people who had fled to the Union lines had actually been returned to slavery. So what is the takeaway for us? What is the lesson for us from this extraordinary act by Lincoln? I want to be clear that it's not that whoever is the President of the United States has the authority to reinterpret the Constitution in violation of what everybody else thinks it means in order to reach the result that he likes. And Would that we lived in a world where such an idea was laughable. I would like you to be laughing at it, but we also shouldn't be laughing at that. So that's not what the lesson is. The lesson is that in the crucible of existential crisis, the crisis that could have ended the Union, the crisis that ended the lives of so many people in the war, someone who has a deep commitment in conscience to obeying an oath registered in heaven doesn't have all the answers simply from the fact that he or she says, I will follow my oath. That's just the first step. You then have to understand what your oath is to, and you have to interpret the content of your commitments in order to live up to them. And in that, we need all the help we can get. We need the guidance of our elders and betters. We need the wisdom of tradition and the ages. We need a clear moral compass. We need to be cognizant of sources of authority. And in the end, in the final analysis, it will be up to each of us within our own conscience to make sure that we can look our Maker straight in the eye and say that we sincerely and truthfully obeyed our oaths that we have registered in heaven. Thank you, and I'm very eager for conversation, and in the spirit of law school where I ordinarily teach, if a question takes the form of, you don't know what you're talking about, I will welcome that question, and I will enjoy it. So I want to officially authorize you to challenge.
So I'm going to ask Noah to stay up here with me, and we'll maybe share the podium a little bit. As pretty much all of you can see, there are microphones on either side here. Those are primarily for our audience who is not with us, who's watching via a live stream, so that if I were just to ask the audience questions, we would hear, Noah would hear it, but people at home would never hear it. So if you have a question, please go to the mics, and I'll just kind of call on people right and left. We have about 15, 20 minutes. If they're good questions, maybe a little bit longer. With that in mind, I encourage, that's right. I encourage people to ask actual questions rather than, maybe, well, I don't know, you invited a challenge as well. So, okay, the one privilege that comes from being the host in this situation, the person at least who kind of is welcoming everyone, is I can ask the first question, right? I'd love to ask, for maybe just a bit of a clarification. That, and here this is again speaking as a historian, we care deeply about change over time, how to account for change. And you brought up Lincoln changing his mind. And I guess the question that kept coming to my mind is, if we broaden this out, would you say the Constitution and constitutional principles change because of expediency, or because of sort of, because we're in these crucible moments and therefore the Constitution has to change, and the pressure builds up? Or is it more gradual? And I'm saying this also, I'm making this a terribly complicated question, no, but I'm always thinking in the back of my head of that Oliver Wendell Holmes line, great cases make bad law. So I'm wondering if crucible moments actually don't make for good change. So anyway, if that makes some sense, please take that, and then we'll call on the folks over here.
Okay, great. That's a wonderful question, and I'm going to quote Holmes back at you. In almost exactly a century ago, in actually a century and a few years, in 1919, Holmes wrote an opinion in a case called Missouri against Holland. And in that case, he introduced the metaphor of the Constitution as a living, breathing organism. And he said that our forefathers could not have foreseen every circumstance that would arise. They only knew that they were making a nation, and they aspired for it to live, breathe, and survive. I'm paraphrasing a little bit there. And I am deeply influenced by Holmes's view that the right way to understand our Constitution is embodying a blueprint with values and principles that are permanent, that nevertheless has the capacity over time to evolve and change, much in the way a line of organisms has to. And Holmes was by way of being a bit of a social Darwinist, and he meant the metaphor. He meant that your alternatives in life are to evolve or to die. Now, Justice Scalia, who, among other things, a great scholar, great justice, great sense of humor, used to insist that he was against the idea of a living Constitution. He would say, the Constitution is dead. It's dead, dead, dead. And he could get a good laugh out of that because he was Justice Scalia. I couldn't get a laugh out of it. But in my view, I'm influenced by Holmes's idea. I believe that the alternative to a living Constitution is one that would be frozen. Now, as we know, evolutionary biology itself has gone through controversy over how evolution works. At one time, people imagined that evolution must be completely gradual, very, very slow and steady. And then others thought, they were called the catastrophists, no, evolution happens in big moments, in spurts. And ultimately, the view that has come to be at least somewhat prevalent now, although things can always change among the biologists, is that there's some of each. That sometimes there's punctuated equilibrium, where things are pretty much steady state, and then something big will happen. You know, an enormous asteroid hits the Earth, and we get the Cretaceous Tertiary boundary and the extinction of the dinosaurs. And that's punctuated evolution. And other times, you get very slow, steady evolution. It's pretty obvious that in the case of the Constitution and all human institutions, we're a lot happier and better off when it's gradual. We want it to be gradual. But we can't always control events, and the Civil War is an example. And so the years of Lincoln's actions and his abolition of slavery and then the passage of the 13th, 14th, and 15th Amendments are an example of the crucible, the catastrophe, and evolution emerging on the other side of it.
All right, to my right, if you want to ask a question.
I just deeply want to thank you for this address and wish that it was broadcast in every high school, every middle school, and hopefully in all the elite colleges of the United States, where we have had such a loss of what it means to have a constitution and how it can change, as you have used the example of Lincoln. I very carefully ask you this question because I would like to put your talk in the context of the country that we live in today. Sorry, I cannot forget where we are. We are polarized between progressivism and extremism on that side, and Antifa and extremism on that side. We are polarized. We have the example of Lincoln using executive orders, which is what I called what he did. I didn't call it what you called it. I didn't know that's what it was called, but because I'm not a lawyer, I'm just a mom. Okay, it's called a mom move to save the family. And what we have taking place today after what people would call the Great Reset, because we are looking at the UN to run our country, and all of that, all those conspiracies, all that goes that way, or I should put it on that side, sorry, and then it goes that way. You know exactly where I'm going, okay? You know where I'm going. How in the world, what can we, normal, everyday person who's going to be showing up in Maryland based on our understanding of what the Constitution is and how can we live in a country today where we have a president doing what he's doing, and where we have what's happening to our institutions and what's happening to the Supreme Court and what's happening all over this country? What is your strongest recommendation?
Thanks for asking me an easy one. So first of all, thank you very, very much for that extremely heartfelt and thoughtful question. I think you're speaking for many, many, many people across the country who are deeply troubled by our polarization and who see that to respond to one extreme on one side with extremity on the other side puts us in a vicious cycle that is only going to make everybody worse off. So thank you. To my mind, we do have an escape valve to the continuing polarization that we have, but that escape valve has the virtue of being there and the demerit of not always working fast. And the escape valve I have in mind is actually the basic structure of democracy. And it's that in the end, in a system that is still essentially a two-party system, and there are political scientific reasons that it has remained so, you have to ultimately win the votes of people in the middle to control either House of Congress or to control the presidency for any length of time. Now, our system is set up so that you could win fewer votes and become president, and that's happened several times in recent history. And our system is also set up that you can win fewer votes and control a House of Congress. And our system is also set up so that a party that gains control of a state legislature can politically gerrymander to keep itself in power. And both parties have been perfectly capable of doing that on occasion. So there are structures there that have helped give rise to the polarization that you're describing. But none of those structures is consistent with a long-term situation in which a clear majority of the public is deeply troubled at a fundamental level by what's happening on the other side. Because when that happens, people will begin to turn out and vote. And when they do, that pushes both parties back to the center. I have faith that the laws of political science have not been fundamentally dislodged in the last 6 years. There are moments when it looks as though they have been. And certainly we haven't seen polarization this bad, certainly in my adult lifetime. But I believe that those principles and rules are still there, that more reasonable people, or maybe that's an unfair term to use, but more centrist people at least, are out there speaking to the public on both sides and will gradually offer the public options that the public can accept, and that will happen before our mutual disputes become so bad that we can no longer sit in a room together. And I'll tell you why I have faith in that. It's that I get in my job, I'm lucky enough to be able to travel around the country to places that aren't on the evening news every day. And many, many, many people have asked me questions or told me things closely comparable to what you've just said. What you are expressing is the mainstream view of most people in the United States. Most people are pretty sick of it and really believe that we could get back to a world where we're not moralizing on both sides and treating the other as an enemy rather than as somebody who shares our deepest commitments to our Constitution but sees a little differently how we should get there. So I think it will be okay in the end, but it's taking longer than one would have hoped, and it may take longer still. It may take longer still.
Yeah, let me go to my left to actually a student from one of my classes, but we've only had class for 2 weeks. So Ethan? Bryce, all right, there we go. I won't make that mistake again.
It's okay.
Anyway.
So I have a similar multi-part question. In your opinion, what is the greatest danger to the Constitution currently? And what is your message specifically to this rising generation of college students on how to defend it from such?
Thank you. I think the greatest danger is actually connected to a message to college students. The greatest danger is that people in your generation will look at the people in my generation and cease to believe that what we're trying to do, and with reason, by the way, not as a mistake, but with reason, cease to believe that what we're trying to do is argue about what we believe the Constitution really means by our best lights. Look at the people on the Supreme Court and think, it's not that they're principled people with a lot of the same principles who reach opposite conclusions, but rather each has an agenda, they're pushing that agenda, and they do not care about the true meaning of the Constitution in that process. And I hear that line equally on both sides. Miraculously, they're always talking about the other side when they say that. They always say, we have principles, they're opportunists, they're agenda-driven. We just follow the meaning of the document. They can't both be right about, well, maybe they could both be right about that. That would be a tragedy. And if your generation looks at the deep disputes that we're having, constitutionally now I'm talking about, I'm not talking about political polarization, but constitutional dispute and debate. And by the way, it's going to get harder because the contentious decisions that the Supreme Court reached last June they're not the end of the contentious decisions on hot button issues. There are going to be at least 2 more this next June, and possibly more than that, and it's going to continue for a while. So controversy about the meaning of the Constitution is going to remain heated, very heated. And so if you guys look at us and say, you know what, this system is ridiculous. People are just pointing at this document and it doesn't mean anything to any of them. Then that will cause a loss of faith in the core idea of the Constitution. And the core idea of the Constitution is that we, the people, have enough consensus on our capacity to live together, that we can solve our problems under this rubric, acknowledging that there are some hard cases of interpretation where we're going to disagree in good conscience. That's constitutional government. And that means looking at the people who issue a decision that I disagree with deeply and saying, I know them, they acted in good conscience, and I think they're wrong. And for them to look at me or look at the other side and say exactly the same. So what I am saying to you, and what I do say to your generation of students is, try to interpret us charitably. Try to identify the points where we do actually have agreement on the fundamentals of the Constitution, on the fundamental of the rule of law, on the fundamental of equal protection, and on the fundamental idea that the courts exist to interpret the Constitution and the Bill of Rights to protect the most vulnerable. And then if we want to have an argument about who are the most vulnerable and what the correct interpretation of those rights is, let's do so appropriately enough in that spirit of charity. You know, we need to understand that humans will do the interpretation, but that if we do that work collectively, there's room for some disagreement, even intense disagreement. That's how the Constitution has been working all this time. The one time when we really couldn't agree, we had a civil war. We don't want to do that again, and we're not going to do that again. And that's evidence, that's the first piece of evidence. You know, we're not going to break into 2 countries. That's a preposterous idea. It's not just a bad idea, it's a preposterous idea. We're not going to have a civil war. Also, not just a bad idea, a preposterous idea. So that's the starting place of recognizing what works in the system. And I hope we can convince you to notice that.
Thank you.
All right, we'll go back to my right, and let's see, we're already at 5 o'clock, so this may be our last question. We'll see, we can go fast, so go ahead.
This should hopefully be shorter. So, in your opinion, do you think that the Confederacy could have survived as an independent nation had, say, in 1862, they achieved total independence? Do you think because of the way they were not fully federal and, you know, kind of a weak executive and national power, do you think they could have sustained themselves as a nation? Or do you think potentially states could have come back over the next 50, 100 years per se after an official split?
I mean, first of all, yes, I think they could have survived. You know, Canada would not have been an independent country if it were not for James Madison, who tried to invade it in 1812, having designed a constitution that was really good for self-defense. The well-regulated militias were designed for self-defense, and they were terrible at going to war. And so he massively bungled the invasion of Canada, so Canada ended up eventually becoming its own country without big defenses, pretty federal, very federal, did just fine. So, you know, yes, I think they could have survived. Might they have come back? Conceivable, but unlikely.
All right, then this may be our last one with all, sorry, deference to those who are still in line. Let's go back over here to my left.
Hi, thank you so much for your remarks. We really appreciate them today. There's a growing group of particular young people, irrespective of political party, who would regard the Constitution as a document that keeps a certain class of people in power. How might other young people, in discussions with our peers, defend the Constitution as a document that offers hope and protection in a respectful way?
It's another great question. The first step, I think, is to be honest with your interlocutors in saying that the people who framed the Constitution didn't want just anyone to come to power. You know, I mean, Alexander Hamilton in the Federalist Papers said, we don't want to be too much of a democracy because then the public will elect, quote, celebrated persons rather than people who are well qualified to run our country. You know, I mean, fortunately for us, that's inconceivable to have happened. So I think you have to begin with honesty. You have to say that the Constitution was meant in the first instance to try in some way to get the wisest and the best people elected, and that it doesn't always work. And furthermore, that our system of first past the post elections was designed to drive voters to the middle, which is why I have faith that it will do that again. Not designed to enable the emergence of peripheral political parties having the opportunity to come to power in a complex, fragmented parliamentary system. So you gotta be honest, the system isn't designed so that Eugene V. Debs could become president of the United States, you know, a socialist. It's not designed for that. It's designed to drive candidates towards the middle. And then you say, well, is that a good or a bad thing? If you're a genuine radical on either side, it's a bad thing. If you're convinced that you know that the right way the country should go is through radical transformation, you can't get there so easily because the system isn't set up to facilitate that. So you have to begin by acknowledging that. Then I think you say to them, but have transformative voices been able to make their way into American political life, notwithstanding their peripheral nature? And the answer to that is yes. And I would use Dr. Martin Luther King as the model of somebody who, you know, somebody who has a national holiday named for him and who was imprisoned repeatedly in his lifetime. And ultimately, King's famous I Have a Dream speech entered our constitutional lexicon and offered a reinterpretation of Lincoln's second inaugural in which the ultimate promise of equality could be redeemed, notwithstanding the many years in which that promise was unredeemed. And this is a man who was born in the segregated South, where he lacked the right to vote and lacked many other basic civil rights. So we have precedent in our relatively recent history of peripheral voices issuing a call to justice in expressly religious and indeed prophetic terms and being listened to and incorporated into our national narrative. That happened too. And it could happen again under the right circumstances. And that's one reason that I have faith in both senses of the word faith, a civic faith and a civic religious faith in our possibilities as a country. Not because our Constitution is perfect, because our Constitution, inspired though it may be, nevertheless has to deal with real human beings in the real world, and humans have to interpret it, and humans are not perfect. So, you know, it follows that as a way of doing real life decision making, the Constitution will not always produce in every instance a perfect result. Joseph Smith, I learned recently, uttered the words that give rise to the teaching of an inspired Constitution while he was in prison. While he was in prison. So the takeaway is clear. One may have a justified, profound faith in the capacities of our Constitution, even in a moment when the Constitution is not achieving what it is meant to achieve. And so our Constitution exists in aspiration and in hope, and also, we hope and aspire, in practice. Thank you.